outlines Township's compliance review process. The ordinance requires all applications deemed to be complete shall be forwarded for review to the Township engineer, the Township Planning Commission, the Township Planning Consultant, the Allegheny County Economic Development Group, and the Allegheny County Conservation District, and others as appropriate. It also mandates on the Friday preceding the fourth Wednesday of each month, the code enforcement officer will submit a documentation packet for consideration by the Planning Commission at the next meeting. Now, this is never met because this information dribbles in at the last moment. But I'm going to tell you, as of this morning, and you can see on Exhibit B, as of this morning, November 25th, 2025, we have an email correspondence with Matt Gordon, direct email from Matt Gordon, the Director of the Allegheny County Conservation District. No final plan for this development has been submitted to their office, and no application for the MPDES. Both confirmed as not received as of today, this morning, by the Allegheny County Conservation District. In addition, that county agency is owed a full 30-day review period before this commission may consider this plan again. So can we please explain why the Allegheny County Conservation District did not receive a final copy of this as required by the ordinances? We have an email from Matt Gordon said he never received the email. We actually had a comment here that you're in communication with the Allegheny County Conservation District. That is absolutely news to Matt Gordon because he's not heard of any of this other than from Jason and myself. No communication. How does that happen? Why do these guys stand here before you and tell you something that's happened and it's not? And now we're at a point at the ninth hour. I would love you to reach out to Matt Gordon and have him explain to you what has and what hasn't happened. I would also love for him to explain, and Dan, you're saying, if I could ask you a question, you're saying you can't file for the MPDES report until this group and the Board of Supervisors votes yes. You're saying that because that's what you said here tonight. They can't get it until there's a yes vote to all this stuff is taken care of. Because that is absolutely news. I just want to make sure that's what you said, and we have it on video. Is that what you meant to say?
Okay. Can I speak now?
Absolutely.
I don't know. I mean, the developer has his engineer to speak to this. The NPDES permit process runs to the Allegheny County Conservation District. And what I think I heard Mr. Foster say was, as deemed appropriate, the things are submitted. So this plan isn't deemed appropriate to be submitted, as I explained before, until it goes through the township ordinances first. The federal permit, they need a letter of compliance. I can't write a compliance letter until they run through the process, if that makes sense. So they really can't get the MPDES permit, and there's several other plans that I'm aware of that I've reviewed in other communities. People run through the community process first, and then the NPDES permit follows after that. So there's an extra layer of scrutiny on it. It takes anywhere from, well, I'm just explaining the way it happens. When a plan is submitted to this board, we have up to 90 days to review it. And if it meets our requirements at that point in time, then we have to make a decision and either approve it or not approve it. What happens is when it goes to for the MPDES application, that can take up 6 months to a year.
A year plus.
Yeah. So
Before a shovel can hit the ground, or a tree be cleared.
You're completely correct, yes. But again, the process has reached the point where you can't get that. In other words, we have to write down a letter that says that it complies with our ordinance first. And we can't write that letter until it runs through this process. That's all.
You're saying you can't write a letter saying it complies with all the ordinances until it's approved?
Well, I don't think the Board of Supervisors would appreciate me writing a letter on a project until they got to understand it themselves first. So it has
Even though they put it as a contingency, they didn't say apply for a permit, they said obtain a permit.
Well, the solicitor can speak to that. I mean, a federal permit, so we have to get through our process first. I don't feel comfortable writing a letter to give to this developer until they run through our process, and that's typically the way it works. So there's a point in time where we feel comfortable with that. I would feel comfortable with that now because we've been through 5 months of review on the plan. Now I would feel comfortable writing that letter.
Wait, what do you mean now before they get approved?
No, technically, I'm ready to write that letter, but I'm waiting for the township to give its blessing first.
Thank you. I'm gonna urge the board, and I've got a couple other items. You guys need to have a conversation with Matt Trapel, who's the director of the Allegheny County Economic Development Group, and Matt Gordon, the director of the Allegheny County Conservation District, because you're gonna get a completely different story of how things work. Matt Trapel, he is the planning commission for about 36 municipalities, so he does this at maximum speed. He has never heard of a board even contemplating meeting before that permit is secured. And that's why clearly the Board of Supervisors, and I'm gonna get to that point here, but clearly the Board of Supervisors put obtain. It didn't put apply. Obtain is a very clear word, and that's what it should be. Because this development with all the complexities, there's 12 or so items, depending on whether it's a general permit or an individual permit. This clearly needs 10 of the 12, so it's gonna require an individual permit, which is a year-long process at least. There's a 30-day public comment period. How in the world, why in the world would a planning commission or a board of supervisors ever approve something that is a year away, that is gonna undergo so much scrutiny and then so much new detail? It could really be embarrassing for the township to say, wait a minute, there's all these issues associated with this project. You approved this a year ago and had no idea of all these issues? That's why it's unheard of. I urge somebody, all of you, or a representative, talk to these two people who do this, because these stories you're being told today make no sense. I'm gonna just urge that.
Can I just make one other comment related to that? I respect what Mr. Foster has said, but I just want to make sure that everybody understands the scrutiny that the County Conservation District make on these plans will not affect the plan as you're approving it tonight. In other words, their review is strictly related to erosion and sedimentation control and stormwater management. So, yes, they may require the stormwater, an orifice in a pond to be adjusted. They may require a ditch to move, but those are temporary conditions. They won't change the location of the streets, the location of the sanitary source, the location of the storm source, all the things that the township cares about. So I just wanted to provide that clarity to everyone here. And I mean, I've been in this business for 40 years. Regulations are very complicated, and in the world today, this is, I represent at least 7 different communities, and everywhere in those communities, an NPDS permit follows a local approval. So I'm just, again, providing that for your information.
Yeah, that's what Jim, can talk, I'm sorry, my name's Bernie Lamb. I'm representing Worcester and Associates, the civil and traffic engineer on the project. We have met with Matt Gordon, the Conservation District, 2 different times, one with the developer and one just with the technical staff. And so he is aware of the project. I don't know if maybe he thought it was still called Sleepy Hollow or whatever, but we have met with them a couple times already. And they do actually have the checks for the application already in hand. And we are just literally waiting to get this approval to make that.
The pre-application meeting was over a year ago.
We've had 2, we've had 2 pre-application meetings. Yeah.
Well, I talk to them every few weeks, so.
We've had 2. We haven't had one.
Does he have a copy of the final plan that's required by our ordinances?
We haven't made a submission to them.
There you go.
Yeah, because he doesn't want to see one before it gets approved. It's a waste of time.
You talked to him and he said that. This is all being recorded. I hope you guys are.
We've had a meeting. It is being recorded, Tim, and you said that he doesn't know anything about it.
Okay.
I'm going to call him tomorrow and let you know that he does know about this project, because we've met with him twice on that.
Yeah, and I hope the board can do that too, because you are going to get a completely different story from what you're being told here today. It's unbelievable. Point number 3, extensive missing and deferred items under final application requirements. Beyond missing agency reviews, the application also fails to comply with Southport Township Code 118-15 governing final application content. This section requires detailed final plan submissions including plat information, construction plans, development plan information, certificates, notifications, and other mandatory reports. Many of these required items are still missing, deferred, or unverified. An application in this condition cannot legally be considered for final approval until every deficiency is addressed. The attached list outlines more than 50 required items, many still incomplete. Gateway Engineering letter dated November 21st, 2025 further confirmed that the final application is not complete under the Saldo ordinances. A question you must consider is when comparing the October Gateway letter versus the November Gateway letter, why many of the October concerns that were expressed in that October letter were never documented as resolved. They just vanished. They're gone from the November letter. I have never seen anything like that. Where's completed? Where's satisfied? Nothing. They just went away. They went away. Township compliance. The November letter. These are obviously required items according to the ordinances. If they were such a concern, they should not go away, and they should not be ignored. These items need to show as resolved if we were to ever trust this engineering report by our paid township advisor, Gateway. Dan, if I could just get clarification from you on the record. This is our ordinances, 118-15. So there's 50-some items in there. Are you stating for the record tonight that to your satisfaction, all of those items are complete and documented?
Sure, would you like to go through them all?
No, if you want to say that they're complete and documented, because
Yes.
all of a sudden they weren't on your November letter, but they were never listed as completed.
When we work through different iterations of reviews, if a comment has been addressed, we typically take it off because it's been addressed. So the comments didn't vanish, they were addressed. I'm glad to document it further if Mr. Foster, I can give the township a report on whether from one review to the next that it's been addressed. That's just the semantics of the way it occurred. I don't want anybody to think that there was anything that vanished. I mean, that's why we had 5 different iterations of this plan that we went through it, and as we work through it, the comments come off, and that's typically the way I do it. So that's just an explanation.
With that said, for every time we've had a review and a comment letter from both Gateway Engineers and EPD, as part of our next submittal at the beginning of the month, we always supply a response letter to say how that item is addressed. If it's addressed, as Mr. Israel mentioned, it's not, it's removed from his comment letter. So we always give a response in regard to the traffic engineering comments, planning comments, civil comments, as well as we provided responses to the Allegheny County. So.
I hope that doesn't make sense to the board. Because if you're looking at an October letter that has a laundry list of items that is missing, then all of a sudden you look at a November letter, you are supposed to assume as a board, and we're supposed to assume as a township, that they got completed. I mean, you know, I would strongly recommend, again, tabling this until you get a full list of all those documents that have been completed. Because I think right now they're going to be scrambling to complete that, based on what I'm hearing tonight. That's unheard of. If you have them listed, you carry them forward and check submitted on them. Check completed, not disappear on the list. Item 4, an additional legal barrier, 9 unmet contingencies attached to the preliminary approval. Lastly, we must address the 9 contingencies attached to the Board of Supervisors May 12, 2024 conditional approval. In particular, item number 5, the developer must obtain the NPDES permit. Please note, it does not say apply, it does not say intend to get, it requires the developer to obtain the permit fully in hand. How else can obtain be defined? I have it as Exhibit D. This is not a technicality. It is a mandatory condition of the preliminary approval that remains unmet. Pennsylvania case law is crystal clear on this. In Lyonsboro versus Township of Maxitawny from 2015, the Pennsylvania Commonwealth Court, the appellate court, ruled that under the municipality's planning code, final approval cannot be granted until all conditions attached to the preliminary approval are satisfied. Because the conditions in that case remained pending, the court held that approving the final plan was premature, improper, and a violation of the saldo. The ruling is significant because it reaffirms that while municipalities may impose conditions at the preliminary stage, they cannot carry unsatisfied conditions forward into final approval. Doing so undermines statutory planning safeguards and violates the purpose and structure of the municipality planning code. In simple terms, final approval must wait until every preliminary condition is fully met, not partially, not eventually, but fully. This is binding appellate law in Pennsylvania. I'm sorry, I just said one more item. Once again, we have quite a number of conclusive reasons why this matter is premature before the Planning Commission tonight. Under both the Township ordinances and the Commonwealth Court precedent, the Planning Commission must find that this final application is not proper, not complete, and not eligible for consideration. Thank you.
Thank you, Mr. Foster. Diane?
Good evening, my name is Diane Foster, F-O-S-T-E-R. I'm at 1046 Westchester Road. Members of the Planning Commission, tonight I'm asking you to protect something that has existed in South Park for more than a century, long before subdivisions, zoning codes, or even automobiles. Sleepy Hollow Road is and always has been the only safe access horses and riders have to the county park trail system. This is not an opinion. It is a documented, lawful, pre-existing, non-conforming use, a constitutionally protected property right under Pennsylvania law. And tonight, that right is in jeopardy. Pennsylvania courts have been clear. A lawful, non-conforming use is a vested right that cannot be removed or made impossible by new development. It runs with the land, it survives ownership changes and modern upgrades. Municipalities have affirmative duty to recognize and accommodate the use when reviewing development. In 2024, the Commonwealth Appellate Court reaffirmed this. Zoning bodies must make factual findings and require accommodations when a protected use exists. Ignoring it is not allowed, legally or procedurally. This equestrian use is not a hobby. It is a protected use of land, and the township is legally required to safeguard it. Sleepy Hollow Road is narrow and physically constrained. Everyone seems to acknowledge it cannot be widened enough to support both the heavy traffic subdivision from the subdivision and the historic horse traffic. But those physical limitations do not erase the protected use. They do the opposite. They make accommodations mandatory. If a developer selects land with steep slopes, stream banks, and a century-old protected use, that does not excuse them from compliance. It means they must design around the constraints, not eliminate what already exists. Required accommodations may include a separate bridle path or shoulder, a dedicated horse lane built into the upgrade, a safe engineered equestrian route over the bridge. These aren't nice extras. These are legally required when a protected use would be otherwise extinguished. Saying there's no space or it's just too expensive is not a legal justification to eliminate a non-conforming use. If this plan, as designed, cannot preserve the protected equestrian access, then the issue is with the plan, not with the riders, not with the township, and not with history. Approving a plan that knowingly wipes out a protected use exposes our township to legal challenges, zoning appeals, acre claims, and lawsuits from the Pennsylvania Attorney General. This is all avoidable. but only if the commission requires compliance now, before final approval. Horses have used this road for more than 100 years. Families in this township have watched this for generations. It's a part of our identity, our history, and our community character. These riders are not newcomers, and they're not trespassers. They are the original users of this corridor, and they have never abandoned it. Eliminating this use is not only unlawful, it erases a living piece of South Park's heritage. Tonight, I'm asking you to do what the law and basic fairness requires. Do not grant final approval to any plan that eliminates or endangers the protected equestrian use of Sleepy Hollow Road. Require, as a condition of approval, a safe, engineered accommodation for equestrian passage, a dedicated lane or bridle path, including safe bridge access, a clear written finding of fact acknowledging the protected non-conforming use. If the developer cannot design a plan that protects the existing right, then the density, layout, or even the concept must change. That is not the township's failure. It is simply the reality of developing constrained land. Sleepy Hollow Road is more than pavement. It is a century of documented lawful use, and the township has a legal duty to preserve it. Please do not approve a plan that violates state law, erases historic rights, and exposes this municipality to avoidable liability and certain litigation. Do the right thing. Do the lawful thing. Require a plan that protects what has existed for generations and must continue to exist under the law. Thank you for your time. I know how you guys feel, how our citizens feel, because the last time the Board of Supervisors didn't listen to us. And you know what? They didn't listen to you guys either.
Yes, I have some documents for you guys.
My name is Jason Sobek. I'm a resident of South Park Township at 1750 Stoltz Road. Tonight you are being asked to vote on two questions. One, whether the developer's final application should be accepted as complete, and two, whether or not to recommend approval to the Board of Supervisors. I urge you to vote no on both counts, most importantly to refuse to accept this application as complete. This is not a close call. South Park Township Saldo in the Pennsylvania Municipalities Planning Code, your duty is to protect the public health, safety, welfare, and to recommend approval only where a complete, compliant, and safe record exists. Where critical prerequisites are missing, you must find the application incomplete and recommend denial. Last year, you looked at Majestic Woods and you voted not to recommend it. You did that because you saw unresolved safety risks and missing requirements. The fact that the supervisors overrode your recommendation doesn't make your judgment irrelevant. It makes it more important. Your vote is a formal part of the land use record, and it's one of the protections residents have when a plan is unsafe or incomplete. Tonight you have a gatekeeping rule. And if this final submission is missing mandatory steps, missing outside agency review, or resting on invalid preliminary approval, Saldo says you should find it incomplete. That stops the deemed approval clock and prevents the township from being back into approval by default. Please use your authority tonight. And I want to add that one community reality that underscores how much that authority matters. After the supervisors declined to follow your 2024 recommendation, residents mobilized at a level this township rarely sees. A referendum to expand the Board of Supervisors from 3 to 5 members passed in all 13 voting districts, and the only incumbent on the ballot was defeated in the primary. I'm not saying this to be political or to pressure anybody. I'm saying this because it reflects the depth of the public concern and the level of trust that residents place in this commission to apply the Saldo faithfully. People are paying attention and they are relying on you to make careful, safety-based, ordinance-driven decisions that the record supports. Your own record. When you reviewed preliminary plan on April 24th of 2024, most of you voted not to recommend approval, all but one. Your on-the-record reasons remain not only unresolved, but in many cases aggravated because this is the final stage. We kept hearing, oh, this will all be addressed with final approval. Oh, this is just preliminary approval. This will be addressed with final approval. This is final approval. Commissioner Papenchak cited unsuitable soils, moderate mine subsidence risks requiring expert geotechnical oversight, unresolved neighbor stormwater impacts during construction, lack of planning for equestrian traffic on Sleepy Hollow Road, unsafe school bus access, and the need for significant off-site work, relocation of the utility pole, culvert bridge widening, which hasn't been mentioned tonight. Nobody's been talking about the culvert of the bridge. The developer just kind of glossed over it. It's an old culvert. It's end of useful life. We don't know the weight limit. There's no printout inspection reports. And bringing Sleepy Hollow Road up to code. Commissioner Devine adopted Allegheny County Economic Development's findings on unsafe geometry and insufficient width at the Stoltz-Sleepy Hollow Bridge intersection, and the obstructing telephone pole emphasized this is the sole access point and noted that the developer declined the additional safety improvements requested. Chair Russ Bracker changed from leading to recommend to not recommend strictly on safety. A single access over a culvert creates an unacceptable risk if blocked by flood, storm damage, or a fallen tree, potentially preventing emergency response for more than 100 homes. Commissioner Wyckoff, who is not present tonight, emphasized that the developer refused to cooperate on external safety fixes, and the township should not bear the economic or legal burden for offsite improvements required only because of this project. And that as a recommending body, you must listen to residents where serious public safety concerns are present. Commissioner DePrius concluded that the final plan failed to accommodate the area's unique equestrian activity, nearby stables creating hazards for horses, pedestrians, and motorists on Stoltz and Sleepy Hollow Road without dedicated measures. Those reasons were decisive then, and they're decisive now. Before you reach any engineering merits, SALDO requires you to determine whether the application is complete. 2 independent procedural failures compel a no vote on completeness. I won't repeat everything Tim said, but SALDO section 118.13E provides the applicant shall accept or reject the conditions in writing within 30 days. Failure to accept those conditions shall automatically rescind the approval without written notice. I'm the one that's been filing right to know requests. Tim and I have come down and looked through boxes of documents. We have looked through everything. In Exhibit A, you not only have that ordinance, but you also have Karen's letter to the developer on May 17th of 2024. The developer had 30 days from the date of that letter that Karen sent with the conditions or contingencies of preliminary approval to accept them in writing. The developer did not accept them in writing. The SALDO is very clearly written. Preliminary approval is rescinded. Second, again, ACCD, failure to forward to ACCD. So that's Exhibit B, that's that language. The application was not forwarded to ACCD. I have been in frequent contact with Matt Gordon, who is Regulatory Director at Allegheny County Conservation District. If you look at Exhibit C, you will see an email from him. 2 pages, but the one email, one from Friday, he hadn't received anything. He did not receive the final application as required by the SALDO, and the developer has not even applied for the NPDES permit. I've had phone conversations with Matt Gordon, Regulatory Director at ACCD, and I've been emailing him. He's probably sick of me because comes on the agenda that it's canceled, on the agenda that canceled. So I've been following up with him like crazy, and he said that they had well over a year ago had a pre-application meeting. At that time, the developer was planning on applying for a general NPDES permit, which is essentially a rubber stamp. The specific site conditions require an individual NPDES permit, which is much more stringent, and that could change the plan significantly. They haven't even applied for it. So again, conditions of preliminary approval, what Dan's saying about we can't, until I write my letter, we'll write you a letter. I'm sure that Matt Gordon, if he would have told me, Matt Gordon would have told me, Jason, they can't apply for it until we get this letter, stop bothering me every other week. I literally been driving the guy nuts. So, again, as of this morning, Matt Gordon confirmed that the developer has not even applied or submitted the application for the NPDS permit, which was a condition, obtaining it was a condition of preliminary approval. Groundwater proximity to Sleepy Hollow